Hello everyone, I hope every one of you is doing well. I, Dr. Shikha Dhiman, Assistant Professor, Department of Laws, Guru Nanak Dev University, Amritsar, will be discussing on the topic History and Development of the Constitution of India. Let's start with an introduction. The Constitution is the source of all the powers of the various organs of the government. The various organs of the government such as executive, legislature and judiciary derive their powers from the Constitution. It is considered as the supreme law of the country. All institutions functions under the control of the government itself. The Constitution delineates the powers and responsibilities of various instrumentalities of the state. It imposes limitation upon them and also regulates the relations between the state and its population. The constitution of any country is considered to be the outcome of historical development. It evolves with the time and therefore it cannot be said that it is created in a day. The origin and growth of the Indian Constitution have its roots in the Indian history during the British period. From 1773 onwards, various acts were passed by the British government for the governance of India. However, none of them satisfied the Indian aspirations, mainly because they were imposed by the alien rulers. Let's start with the historical perspective. The period of historical British constitutional experiments in India can be divided into two phases. Phase 1. Constitutional experiment during the rule of East India Company that started from 1773 till 1857. Second phase was constitutional experiments under the British Crown, which started from 1857 till 1947 when the India got independence. Now let's talk about advent of British in India. East India Company was established in 1600 AD in England. The East India Company secured a charter from Queen Elizabeth in 1600. The charter granted the company with the monopoly of trade with the East. The first settlement of the company was at Surat in 1608. It was established as a result of the royal famine from Jahangir. In the course of time, many factories at Bombay, Calcutta and Madras became chief settlements or the presidencies of the company. The Charter of 1601 gave the company the power to make reasonable laws, orders and also the ordinances for good governance of the company. The power conferred was the power of minor legislation and they could not make any fundamental change in the Indian law. Let's begin with the charter, that is the Charter of 1726. This charter authorized the governor and council of 3 presidencies to make law and impose punishments for their contravention. These were not to be effective unless approved and confirmed by the company's court of directors in England. The charter also established Mayor's Court in Bombay, Calcutta and Madras and introduced the English laws in these presidencies. In 1757, the Battle of Plassey took place and the company defeated Sirajuddaulah, the Nawab of Bengal and laid foundation of British Empire. In 1765, Shah Alam granted Diwani rights of Bengal, Bihar and Odisha to the company. The responsibility of collection of revenue, which also involved the civil administration. Then came the Regulating Act of 1773. The Regulating Act of 1773 asserted the right of British Parliament to regulate the affairs of East India Company. The Act changed the constitution of Court of Directors of the company and also strengthened the control of British government over the company. The Act appointed Governor General and 4 councillors for the Presidency of Bengal. The council was also vested with the powers of superintendence and control of the government of Bombay and Madras Presidency. The Governor of Bengal was designated as the Governor General of Bengal. Lord Warren Hastings was then appointed as the Governor General of Bengal. The Act also provided for the establishment of Supreme Court at Fort Williams in Calcutta in 1774. The court consisted of Chief Justice and 3 other judges. Sir Elijah Impey was the first Chief Justice of the Supreme Court at Calcutta. After this, there came the Pitt's India Act of 1774. It was introduced to remove the defects of Regulating Act of 1773. It was named after the British Prime Minister William Pitt. The Act distinguished between the commercial and political affairs of the company. A joint government of British India run by the Crown and the company was established. The government now had the ultimate powers and authorities. A court of directors was formed consisting of 6 commissioners was established only for the purpose of political affairs. The court of directors managed the commercial affairs of the company while the political affairs were managed by the board of control. Along with this, the Governor General's Council was reduced from 4 members to 3 members. The Governor's Council were established in Bombay and Madras. Thereafter came the Charter Act of 1813. This charter took away the exclusive trading rights from the company. The trade was thrown open to all the British merchants. The regulations made by the councils in India were required to be laid before the British Parliament. It allotted Rs 1 lakh to promote education to Indian children. Financial provisions were also made to encourage a revival in Indian literature and for the promotion of science. But many Christian missionaries were allowed to spread the religion in India. However, again the change was required and the Charter Act of 1833 came. The Governor General of Bengal was designated as the Governor General of India. Lord William Bentinck was appointed as the first Governor General of India. It vested the legislative powers solely in the hands of Governor General in Council. The Council was empowered to make laws and regulations for all the persons. The Charter Act of 1833 legalized the British colonization of India. India's first Law Commission was set up under this Act and Lord Macaulay was made its chairman. After this charter came the Charter Act of 1853. The Act created separate Legislative Council for India consisting of 12 members. Local representation was introduced for the first time in the Indian legislatures. Provisions for recruitment in civil services on the basis of open competition was also introduced. Now let's discuss about phase 2, that is constitutional experiments under the British Crown that ranges from 1857 to 1947. Herein we will start with Government of India Act of 1858. The rule of the company was replaced by the rule of Crown in India. The powers of the British Crown were to be exercised by the Secretary of State for India. He was assisted by the Council of India having 15 members. He was vested with the complete authority and control over the Indian administration through the Viceroy as his agent. The Governor General was made the Viceroy of India. Lord Canning was appointed as the first Viceroy of India, and therefore he abolished the Board of Control and the Court of Directors. Therein came the Indian Councils Act of 1861. The Act enlarged the Council of Governor General for making laws by adding not less than 6 and not more than 12 members. Half of them were non-official members. It introduced Indian representation in institutions like Viceroy's Executive and Legislative Council. Along with that, 3 Indians entered the Legislative Council. Legislative councils were established at the centre level as well as at the provincial level. It provided that the Viceroy's Executive Council should have some Indians as non-official members while transacting the legislative businesses. It further accorded that the statutory recognition to the portfolio system should be there. It further initiated the process of decentralization by restoring the legislative powers to the Bombay and Madras province. Indian Council Act of 1892 came. This act introduced indirect elections, that is, the process of nomination began. It also enlarged the size of the legislative councils. It also enlarged the functions of legislative council and gave them the power to discuss the budget and address all the questions to the executives. Indian Councils Act of 1909. This act is also known as Morley-Minto reforms. It directs the elections to legislative councils. First attempt at introducing a representative and popular element. It changed the name of Central Legislative Council to the Imperial Legislative Council. The member of the Central Legislative Council was increased to 60 from 16. It also introduced a system of communal representation for Muslims by accepting the concept of separate electorates. Also, the Indians for the first time in the Viceroy's Executive Council. The Government of India Act 1919. This act is also known as Montague-Chelmsford reforms. The central subjects were demarcated and separated from those of provincial subjects. The scheme of dual governance, that is known as Darchi, was first time introduced in the provincial subjects. Under the Darchi system, the provincial subjects were divided into two parts, that is, transferred and reserved. On reserved subjects, the governor was not responsible to the Legislative Council. The Act also introduced for the very first time bicameralism at the centre level. Legislative Assembly with 140 members and Legislative Council with 60 members were made. Direct elections. The Act also required that 3 of the 6 members of the Viceroy's Executive Council other than Commander-in-Chief were to be the Indians only, provided for the establishment of the Public Service Commission. Then came the Simons Commission of 1927, a 7-member commission under the chairmanship of Sir John Alsbrook Simon, arrived in British India in 1928 to review the provisions of the Government of India Act 1919. This commission was strongly opposed by the Indians and met with the protests as it has no Indian member. The commission submitted its report in 1930. On the basis of the report of the Government of India Act 1935 was then drafted. Now about the Government of India Act 1935. This Act of 1935 provided for the establishment of an All India Federation consisting of the provinces and the princely states as units, though the envisaged federation never came into being. 3 lists were drafted. The Act divided the powers between the centre and the units into items of 3 lists, namely Federal List, Provincial List and the Concurrent List. The Federal List was for the centre, consisted of 59 items. The Provincial List for the provinces consisted of 54 items, and the Concurrent List for both consisted of 36 items. The residuary powers were vested with the Governor General. That the Act abolished the Darchi system in the provinces and introduced the provincial autonomy. It also provided for the adoption of Darchi at the centre level. However, the Act also introduced bicameralism in 6 out of 11 provinces. These 6 provinces were Assam, Bengal, Bombay, Bihar, Madras and the United Province. Also, the Act provided for the establishment of the Federal Court. The Act entirely abolished the Council of India. Cripps Mission of 1942. Sir Stafford Cripps, a member of British Cabinet, in his declaration for the first time recognized the right of dominion for India. Indians were given promise of liberty to frame their own constitution. It proposed that the Indian Union should be made an independent dominion in the British Commonwealth. The Cabinet Mission Plan of 1946 came. In order to effectuate the transfer of powers from British Raj to Indian leadership, the then British Prime Minister Clement Attlee sent the Cabinet Mission Plan comprising of 3 cabinet ministers, namely Lord Pethick Lawrence, Sir Stafford Cripps and A.V. Alexander. The prime objective of this mission was to help India in achieving independence and setting up a constituent assembly for drafting the Constitution of India. It also proposed to set up interim government with the support of major political parties. Indian Independence Act of 1947. It created 2 dominions, that is India and Pakistan. It led to the creation of Pakistan. Each dominion was to have a Governor General. The Constituent Assembly of both the dominions were empowered to frame laws for their own territories. It declared India as an independent and sovereign state. It also established a responsible government at both the centre and the provinces. It further assigned dual functions, that is the constituent and legislative, to the Constituent Assembly and declared this Dominion legislature as a sovereign body. Lord Mountbatten became the first Governor General of Dominion India. Raja Gopalachari became the first Governor General of Free India. Now, after these appointments, there we come with the framing of Indian Constitution. It was in 1934 that the idea of Constituent Assembly for India was put forward for the first time by M.N. Roy, a pioneer of the communist movement in India and an advocate of radical democratism. In 1935, the INC, that is Indian National Congress, for the first time officially demanded a Constituent Assembly to frame the Constitution of India. In 1938, later on, Jawaharlal Nehru, on behalf of Indian National Congress, declared that the Constitution of Free India must be framed without outside interference by a Constituent Assembly elected on the basis of adult franchise. The demand was therefore finally accepted in principle by British government in what is known as the August Offer of 1940. Therefore, in 1942, Sir Stafford Cripps, a member of cabinet, came to India with a draft proposal of the British government on the framing of the independent constitution to be adopted after World War II. The Cripps proposal were rejected by Muslim League, which wanted India to be divided into 2 autonomous states with 2 separate constituent assemblies. Finally, the cabinet mission was sent to India. While it rejected the idea of 2 constituent assemblies, it put forth a scheme for the Constituent Assembly which more or less satisfied the Muslim League. It was under the Cabinet Mission Plan of 1946 that the Constituent Assembly was constituted to frame a constitution for India. The Constituent Assembly, which had been elected for undivided India and held its first sitting on December 9, 1946, reassembled on 14th August 1947 as Sovereign Constituent Assembly for the Dominion of India. It was elected by indirect election by the members of Provincial Legislative Assembly, that is the lower house, according to the scheme recommended by the cabinet delegation. The essentials of the scheme are: number 1, the provinces elected 292 members while the Indian states were allotted a maximum of 93 seats. Number 2, the seats in which each province were distributed among the 3 main committees, Muslim, Sikh and General, in proportion to their respective population. Third, members of each community in the Provincial Legislative Assembly elected their own representatives by the method of proportional representation with a single transferable vote. Number 4. The method of selection in the case of representative of Indian states was to be determined by consolation. As a result of the partition under the plan of June 3, 1947, a separate constituent assembly was set up for Pakistan. The representatives of Bengal, Punjab, Sindh, Northwestern Frontier Province, Balochistan and Sylhet district of Assam, which had joined Pakistan by referendum, ceased to be the members of Constituent Assembly of India, and there was fresh election in the new provinces of West Bengal and East Punjab. Hence, when the Constituent Assembly reassembled on 31st October 1947, the membership of the House was reduced to 299. Of these, 284 were actually present on November 26, 1949 and appended their signatures to the Constitution as finally it is passed now. The first draft of the Constitution was published by the Drafting Committee in February 1948. In the light of the public comments, criticism, suggestions, the Drafting Committee prepared the second draft, which was then published in October 1948. The Constitution was finally adopted on 26th November 1949, which contained a preamble, 395 articles and 8 schedules. The preamble was enacted after the entire Constitution was already enacted. Some of the provisions of the Constitution came into force on the same day, that is 26th November 1949, and the remaining provisions came into force on 26th January 1950. With time, the Constitution has evolved. It has gone through total of 106 amendments. It now consists of 448 articles, 25 parts and 12 schedules. Now let's conclude the topic. The Constitution of India is a living document. It has been adjusted according to the changes in the society. It can never be static. It is the supreme law of the land. The Constitution is primarily adjective in nature. It lays down the powers of various organs of the government. It lays down the framework for the fundamental rights and fundamental duties for the citizens of India. The Constitution, therefore, is the longest and written constitution around the globe. It took nearly 2 years, 11 months and 18 days, along with an expenditure of 6.4 million to frame and write the entirety of the Constitution, and it has been inspired by various other constitutions from different nations. The spirit of the Indian Constitution has been upheld by Indian judiciary over the years. With the changing time, the Constitution has been evolved over a significant period of time. Over time, it has gone through, as stated earlier, nearly 106 amendments and currently consisting of 448 articles, 25 parts and 12 schedules. Thank you everyone for your time. It was a great pleasure explaining you about the historical development of Indian Constitution. We have discussed the entire concept in a short span of time, and I hope that the listeners have understood and enjoyed the discussion. Stay safe, stay healthy. God bless you. Take care. 1857 to